Giving you a live look from the Supreme Court here. Many people still gathered outside. We've heard from many folks reacting to the news today. The Supreme Court ruling that the Biden administration cannot go forward with its student loan debt program. In a 6-3 decision, the court held that the federal law does not allow the Secretary of Education to cancel more than $430 billion in student loan debt. We want to talk about this further and bring in Seth Berenzweig, who is a friend of the program. Seth, thank you so much for joining us here. Let's just first start with your initial reaction to this news. Were you expecting this?
I was expecting it. It really isn't that much of a shock. The Supreme Court had expressed reservations and skepticism during the hearing in open court, so I really wasn't very surprised with the result. What I was surprised with was the nature of the written opinion. The thing that I found interesting about it was how broadly the implications are. Now, of course, the implications of this are broad in the immediate financial sense because it affects so many individuals in America that have loans. It implicates over $400 billion, but there are also broader implications. This decision is a rebalancing of the constitutional balance of power here in Washington. The reason I say that is because the court did away with the historic deference that is provided to federal agencies in the executive, once known as the Chevron doctrine, and has now essentially replaced it today with a theory known as the major questions doctrine. And this is an approach where the court is saying, look, if there is something that is coming out of the executive that has a significant political or economic implication that raises a major question in any of those categories, Congress has to deal with this expressly and directly. And as Justice Kagan said in the dissent, that's, in her view, ridiculous because there's no way that the Congress in the HEROES Act in 2003 could have anticipated a pandemic. So there is, of course, a very significant aspect of this in terms of the implications for individuals with loans, but this is really a major constitutional redeployment of the balance of power here in Washington.
Yeah, Seth, thank you so much for being with us as you explain this further. I do want to talk a little bit more about the HEROES Act because the Biden administration had relied on that statute to enact the plan, claiming that that gave the Secretary of Education the power to move forward with loan forgiveness, but obviously the majority of the court struck down that argument. Can you talk a little bit more about the act in particular, why it didn't work here?
Sure. So you are correct that it was noted that this should have been permitted under the HEROES Act because this is a piece of federal legislation that allowed the Secretary of Education to provide essentially loan forgiveness in the context of national emergencies. But the Chief Justice, in writing for the 6-3 majority, said that he felt that that interpretation would essentially amount to a rewriting of the statute itself. He said that the statute didn't address this kind of a situation. It is a post 9/11 enactment that was essentially intended to deal more with specific, more targeted national emergencies, such as, unfortunately and tragically, what happened on 9/11. And the majority felt that that application did not have a very good analogy here because it is such a broader, more profound nationwide economic impact. Now, we can follow that logic, but the thing that's interesting about it is that the statute does trigger in the discretion for the Secretary of Education in emergencies, and there were a number of federal and state executive orders recognizing the pandemic as an emergency. So that's why the court did it, but I think that we can also understand from Justice Kagan's dissent why she really thought that this was really a big head scratcher. So not only does this have a huge impact in the space of students, but this is really essentially just a new rules of the game for the balance of power for the constitutional division of powers and authorities here in Washington. And it will also change the landscape most likely for business regulation, because the next time a controversial aspect of regulation in and among the business community comes about, it's probably going to open up the floodgates of litigation for more challenges.
And Seth, this has been a pretty lengthy process so far. What can we say about what comes next from here?
Well, what comes next from here is that students are really going to not be able to do anything, so they're going to be left to the curb. What will happen now is that there's going to be probably a renewed emphasis on what you might even consider to be a new role and tsunami of litigation that will likely be coming into the federal courts over the coming year, because when there are going to be regulations, even notice and rulemaking regulations that are going to impact various industries, this case, because of the reshifting and rebalancing of power, is going to embolden litigants to come in and say, look, if the underlying congressional statute doesn't specifically and expressly address this, we're going to go into court and we're going to fight this. So I suspect that you'll see a lot more battles that'll be coming down the pike as a result of this decision. This is not the first that we've heard of the very broad implications that's going to come down the pike as a result of the court's decision today.
Yeah, and Seth, while we have you, let's also get into this other major decision that was made today. The U.S. Supreme Court argued that the Colorado graphic designer who wanted to make wedding websites does not have to create them for same-sex marriages. Obviously, a landmark decision here, a 6-3 decision today. Can you talk about what the argument was here and ultimately what led to this decision?
Well, this is a very significant decision. We really can't overstate the implications of this from a constitutional and from a business perspective. The litigant in this case was a small web design company based in Colorado. And the litigant said that she felt that being forced to engage in a website design relationship with a gay couple violated not her right to religious freedom, but importantly, freedom of speech under the First Amendment, saying that since her expressive content would be included, that could be interpreted as an adoption of that lifestyle, and that therefore she attacked this on unique First Amendment freedom of speech grounds. The reason why this is very important is because the Supreme Court today took this case out of the typical standard of goods and services. The Colorado statute restricted discrimination based upon providers of goods and services. The court created a new tool in the constitutional toolbox to say, if there is expressive content that's being created, that implicates First Amendment freedom of expression, and therefore she actually won the case. What this is going to do is it's going to create a new battleground for small businesses. For example, not exclusively, but including some conservative red jurisdictions where small businesses can come in and say, look, I don't have to work with you if I disapprove of your lifestyle, because if there's an expressive content to what I'm doing, I now have a new weapon in the toolbox and I can carry this constitutional flag under the First Amendment. I think that there is a underlying similarity between the two cases that we're talking about. In the first case, you'll see more litigation coming in terms of business regulation because of the new challenge and rebalancing of power under the doctrine that we had talked about a moment ago. In this case, there's going to be, I believe, a new wave of business litigation because small businesses now have a new argument that before did not exist, saying that they have a First Amendment right to not do business with certain customers based upon freedom of expression. That is a first. Justice Sotomayor had a searing dissent in that, saying that this is now granting businesses the ability to discriminate based upon protected classifications. So again, it was a very controversial day here at the Supreme Court.
It certainly was. Seth Berenzweig, business and compliance attorney, joining us here to talk more about this. Seth, thanks so much. Any final thoughts here on either of these rulings?
I think it really demonstrates that we have a real majorly staunch conservative majority of the courts. The court and the composition of this court has made it clear that it wanted to restrict executive authority. They're also staking their claim now, not only in religious, but freedom of expression liberties under the First Amendment. So we will expect to see this kind of precedent continue to grow as the Supreme Court starts in its upcoming term.
All right. Well, thank you so much, Seth. Thank you for breaking down each of those rulings. As you said, a very big day at the Supreme Court, and we're going to continue to talk about this throughout our programming. We appreciate you being with us to break it all down for us here in the meantime, so thank you.